presence of the jury. You could step down, ma'am. All right, so let's address the issues of Tiara Malcolm and David Fininky as witnesses.
May I argue that after counsel does?
Yeah, so let me just make sure that we squarely get everything on the record in terms of what defendant's position is. And so defendant's position, do you want to summarize what you knew and when you knew it?
Thank you, Your Honor. Excuse me. As Ms. Almazar testified, she did not know the name of the receptionist. She did not know the name of the doctor that she visited that one day. In the January 17, 2023 discovery responses of defendant, she responded in a verified response that the potential witnesses included her, the plaintiff, and unknown staff employees of the medical center building who intervened during the incident. There was no motion to compel that was filed against that. At that point in time, neither she nor her counsel knew the identity of the two individuals. There's actually another response where, and I don't see it here, but what happens why? My copy of the. Well, I'm not sure where it went to. Oh, yes, it disappeared. Now I've got it. Okay, so in Exhibit 1 to the motion, the supplemental motion that we filed, excuse me. She identified at page 10 Imani Ellis and unknown staff employees at Cedars-Sinai Medical Center, including at least two such persons who intervened during the incident. She described them, identified them as people who intervened, specific people, two people who intervened in the incident, and but she at that point did not know their names. It was years after that she never, had gone there again. Plaintiff's counsel did not move to compel and did not file or serve a response to supplement discovery. Exhibit 2 is a comparable discovery response in January 7, 2023 that also referred similarly to the two by what they had done, at least two such persons who intervened during the incident. It was not until last year, that we learned of.
Did you bring all your glasses today?
Yeah. We added, well, it's not until 2024 that we actually identified Dr. Fininky, which was Ms. Moore's hard work. It wasn't easy. And we put Fininky on the 2024 witness list, which is Exhibit 5 to the memorandum that we filed.
Okay, why don't you move on to Ms. Malcolm?
Okay, and Ms. Malcolm, she was the receptionist. She no longer worked at that firm by the time that the litigation had started at that medical center. And Malcolm's identity was only discovered on July 28, 2025, following further investigation by defendant's counsel. So then we talked about adding her to the exhibit list, witness list, and she was added to our witness list. I think counsel's looking at me like I don't know what I'm talking about, but but I believe that she was put on our witness list. Yes. In July that we filed. There have been times when the court has referred to defendant's witness list, which omitted her, even though they knew of her. Plaintiff's August 9. Oh, I'm sorry. They actually had intended to call these two people as well. They did not identify them by name, even though plaintiff worked there and knew these people. She knew who Dr. Fininky was. He intervened. She knew who this receptionist was. She worked there, plaintiff worked there as well. Their August 9, 2022 discovery response identified as witnesses, quote, employees of doctor's office located near the scene. Then also, plaintiff testified in her deposition, which is Exhibit 4 to the memorandum we filed, quote, she is going to be bringing forward at the time of trial people from the doctor's office. So these are people that she knew about, she didn't identify, we didn't know about it, we found it out on our own, and we promptly disclosed it. Again.
Well, and I guess that's the question is, what is promptly disclosed? You learned about it on the 28th. Did you call plaintiff's counsel and say, hey, we found her?
July 28, 2025 was when Malcolm's identity was discovered, and that's when we added the I think it was July 30th, when we filed, I could be wrong, filed
I believe it was the following week.
the following week. And my colleague will clarify that.
May I respond?
I just want to make sure that I understand the defense position. I don't see anything. I see the next witness list after that is being 820.
That's my, that's the one that I filed.
So when he filed, he admitted her. Oh,
I did not write her name there, because I did not know about it.
well, that's an issue.
And so how did you communicate Miss Malcolm's name to plaintiff's counsel?
May I?
Yes.
Your Honor, we were we were providing drafts for this latest round of the trial filings. And as soon as we found out, we put it on the witness list. And on one of those drafts before they were filed.
And I'm asking, when did that happen?
I'm not sure. I know it was before August 20th.
Okay,
May I read her, Your Honor?
go ahead. Well, actually, let me first start. So, Ms. Ellis, you understand you're still under oath, yes?
Yes.
Okay. I have a declaration from Tiara Malcolm, and she states that you telephoned her approximately 2 months after the incident, and that you asked her for her assistance in pursuing claims, and she said she didn't want to get involved. And she said, quote, she told you, you've got to be kidding me. Did that conversation happen?
Never.
Did you do anything to investigate your claims after the incident?
No.
Okay. All right, go ahead, Mr. John Fawson.
With respect to Malcolm, the first time I learned of it, I was given a partial document which only has about 50 pages. I was given it yesterday for the first time in the middle of the
It
trial.
was on your joint witness list on May 10th in 2024.
What was it?
His name.
I'm talking about the Malcolm, not the name of the
Oh.
doctor.
I'm sorry. Okay, go ahead.
Yes, Your Honor.
Okay.
So what I wanted the court to know is I've been intimately involved with this case. My office is located across the street, 9025 Wilshire Boulevard. As an officer of the court, I declare under penalty of perjury. I never walked inside Dr. Finke's office one time. I never gave him my business card. All that's written there is not me. It's not true. It is false. It is a mistake or false, not my problem. I'm just telling you this as an officer of the court. I will not damage my reputation with you for this small issue. I just want it to be clear.
Okay.
I never
And
did it.
I think there's a perfectly reasonable explanation for this, and that it might have been workers' comp counsel.
I don't think so. I don't know what it was, but it wasn't me.
Did she have an attorney in the workers' comp case?
I understand that she did, but not for this. They're not going to go after this doctor.
No, I understand that, but just to get witnesses to what happened. I don't know.
I don't think, Your Honor, that that's what the purpose was. So
Okay.
is there a need for me to argue more?
No, well, as to Finke, he was on the witness list in 2024.
May I finish? I'm sorry.
Sure.
Oh.
So I wanted to address why you didn't want to do any, you knew who it was. So,
Okay, so I'll address it. Your
Go
Honor,
ahead.
Your Honor, I did spend a lot of time doing the opposition, and I tried to do the same thing with the witness, Miss Belcalis Marlinis Almanzar. Cardi B, she herself testified that she was able to get the doctor's name in a matter of a few days, or whatever it is.
So let's just focus on the fact that in May 10, 2024, you knew who this doctor was.
I did not know.
You knew he was on the witness list.
I don't remember it being on the witness list.
It was.
It could have been,
I'm
but
telling
at
you it
that
was.
time, I believe you, Your Honor. So what I want to say to the court is, at that time, we knew we were not going to trial. It wasn't real yet. What was real was coming to trial now in August. And in discovery, it was never produced. So if it was,
But you never sent supplemental rocks.
I understand. But
Okay.
the point is, when they were responded to, the defendant could have easily gotten the name of Dr. Fininky. She testified today under oath that it was her doctor. The same way plaintiff has to go and get the doctor's information in form rounds, so does the defendant. This goes against the Code of Civil Procedure. It's unfair, it's prejudicial, it's damaging. I wasn't able to depose this person. I get it. I didn't depose the defendant because she was out of state, but I did depose Dr. Rosenberg, and if there were witnesses to this case, I would have deposed them. Why not? So, first of all, Your Honor, with respect to Dr. Fininky, my position is that he should not be allowed to testify for several reasons. Really, he didn't really see anything. He didn't. And it's really not that exciting.
How do you know that?
Because I know that. I know that. And we'll see that. If the court wants to allow him to testify, I'm open to that thought process because he didn't see anything. I really wouldn't care about him. But this random person, Tiara Malcolm, is a problem. Why? Because I wasn't able to take her deposition, cross-examine her. She was never put on any witness list. Even my own that I did on August 20th, when I filed it, it wasn't there. The two individuals that I thought were the witnesses are Dr. Azizolai and Miss Parsi. Those two people are on the witness list. This whole idea came about because counsel said, well, we shouldn't have Azizolai, we shouldn't have Parsi. And then I said, well, then I'm going to jump on the bandwagon too, and you shouldn't have yours. And that's why we're here today, Your Honor.
Okay, so let me refresh my recollection. I don't remember if we had a court reporter at the time. But at the time of our final status conference, there were discussions about this receptionist. I think there were discussions about you were actively engaged in trying to identify her, and you would inform counsel if and when you did. That conversation happened, correct?
Nobody informed me nothing. All I was given,
No, I'm saying at the time of the final status conference, that was a conversation that was had.
I don't remember it that way. I'm not that smart like the court is. I don't remember it that way. All I can say is it's inappropriate to be given a document in the middle of the trial. With this court, the way that it is, it's super fast. The court doesn't want me to spend a lot of time asking people questions and practically doing a deposition. So I would submit that.
Let's just say for the record, I let people try their cases. I'm not going to let you waste the jury's time.
Of course,
Okay?
I understand that. So my request is Tiara Malcolm is out because no one at any point called me, did anything to give me this information till yesterday when their attorney, Lisa Moore, who's not the main attorney, there's another lawyer here, he could have signed the declaration. I don't know why he did it. Why is she doing it? Everything's been done by Peter Anderson and Eric Lamb with all of his other attorneys that he has helped him.
Well, I think she was the one with boots on the ground, according to her declaration. But
Well,
so let's. So we find out about her on the 28th, and I see the witness list on the 20th. So I guess my concern is the gap of period of time, or actually, can you confirm, did we have that conversation that you were actively trying to find her?
That's my recollection, that she definitely came up. I don't recall if we had just found her or if we were still actively trying to find her. Unfortunately, we don't have the back and forth. And for example, Mr. Lamb's, sorry. I think that point's been made. If your honor likes, we can check to see when we actually sent a draft with her name to witness list with her name to counsel. He definitely did not just find out about her yesterday.
I'm sorry.
If I may. And so we can do that. We just can't do it here because we've got a lot of trial documents and not many discovery documents or drafts of discovery documents. But we can't submit that. I can tell you, Your Honor, that once we found her, and this is a woman, by the way, who's integral to the case that plaintiff has known about since day one, and counsel says his office was across the street, but he never bothered to walk across the street to find out her name. Anyway, to make a long story short, we can provide that information. We can check if you like, but we did promptly disclose, I believe it was in a draft joint witness list that we had submitted. We submitted several as soon as we found her within a week.
May I reply, Your Honor?
Go ahead.
This case was set to be tried in 2024. It was continued over and over and over, and discovery was closed. This court did not reopen discovery. So this issue has been sleeping for at least a year, and it's unfair and prejudicial to the plaintiff to allow this random witness to show up at the eve of, not even the eve, in the middle of trial.
I think, let's be fair, you both identified people at the medical center. You both knew that these were people, I mean, your client testified that there was people that came out. So she knew that there were people that came out.
No, the two individuals that I have, these are people that know about the incident. These are not the two individuals that they're talking about. There was nobody at the scene till after the fact. So whoever these people are, they're not going to really say anything fair. And for them to drop it on me in the middle of the trial is unfair. If they want to bring Dr. Fininky and he wants to say, I came out and I heard there was an altercation, I'm not too concerned about him. I'm more concerned about Tierra Malcolm. I have no idea who she is, what she's going to say, and that one has never been given to me. And this case, discovery has been closed for over a year. Why should she be allowed to testify? It doesn't make sense to me.
Your Honor, may I just very briefly?
Sure.
We've been asking, and counsel hasn't told us who this Farzi, I'm not even going to try. I don't know if that's, I just don't know how to pronounce his last name. And the woman, we've been asking how they're relevant, given that Farzi, for lack of just attempt to avoid trying to mangle his last name, he's on 4-3, and he doesn't come in on Saturdays. He wasn't there. And the other person they identified is the receptionist at the building office, which is closed on Saturdays. The suggestion that the two people everyone's been talking about throughout this case who came out of the doctor's office for some reason weren't the doctor and the receptionist is just absurd.
Your Honor, he's testifying to things he doesn't know. How does he know if my doctor and his assistant were there on Saturday? How does he know that?
I don't
If he
know.
can prove me that, I'll withdraw all my objections. He can't. He's just making up stories. He's
Well,
absolutely.
So I guess the question is, let's just talk about reasonable diligence. And so, Plaintiff's counsel knew that the receptionist of the Women's Care of Beverly Hills was at least identified as a category of a person to be a trial witness, correct?
I believe so.
Okay. Did you do anything to try and figure out who that was?
There was nothing to do. It's a 6-year-old issue. I didn't know if somebody could even pop up. Why would they? How could I do it, Your Honor? How? Would it be possible?
All right. And to what extent, if any, is it possible to get her deposed between now and Tuesday?
Well, Your Honor, it sounds like plaintiff is going to be resting tomorrow. We expect her to testify tomorrow. She also, she's out of town. Yeah, that's our plan is for her to testify tomorrow. And if it helps, maybe without the jury, she can give an offer of proof or something. But we're talking about a 30-second incident. The idea that, and by the way, he didn't take Dr. McKenna's deposition. He didn't take, that proceeded without him because he didn't bother to show up. He didn't take the defendant's deposition. The idea that at this late point he gets to take a deposition of someone who he has known about and his client has known about since she worked there, I just don't see the fairness in that.
Your Honor,
All right, let me do this. I'm going to rule that Dr. Fininky can testify. I'm going to take it under submission. I'm going to look a little bit further into the Malcolm issue. I will tell you, I'm leaning, since the person was identified apparently for years, I don't think that it's an unfair surprise that she was finally identified. So that's where I'm leaning, but I'm not going to make that decision right now. So I'll rule tomorrow morning on the issue of the receptions.
Then how about a deposition?
Well, I'll rule tomorrow.
Thank you, Your Honor.
All right.
9:30 tomorrow?
So I think there was a discussion at the final status conference regarding who was demanding jury, and I thought the defendant was this demanding jury.
I assume plaintiff had demanded a jury.
I believe both sides.
I thought both sides.
Oh, okay, so I didn't realize that. We weren't counsel at the time.
No, I think it was addressed at the final status conference in terms of payment of jury fees.
Oh, I don't recall that at all. I'm sorry.
Is that an issue?
No, we'll split them.
Okay, all right. Fine.
My apologies.
Yes,
What did you choose then?
exhibits for today.
Oh, exhibits for today. See, you keep me on track. Are there any exhibits that we're moving into evidence?
I believe there was one that the court, Dr. Mulligan's records and bills.
We already have plaintiff's 9 and plaintiff's 28.
Okay. So defense counsel is going to look at, I'm sorry, the exhibit.
9. This was 15 pages.
No, nine was the CV. I thought.
No, you're right. I apologize. Number 4, it's 15 pages. And counsel has had the whole day to look at the 15 pages, 3 pages of which are bills. And this is something that Dr. Mulligan testified to. I would ask that the court admit these 15 pages of evidence.
Any objections?
If you can bear with us just for a moment, Your Honor.
This first page.
We don't object to the first page, which is the one he questioned him about. Beyond that,
It would be an incomplete exhibit.
okay, how do I identify what we're doing?
So, exhibit 4, pages 1 and 2. Exhibit 4, pages 1 and 2. Defendant can, yeah, that's a document. 1 and 2.
One of the problems, Your Honor, is we're having trouble because he combined as a single exhibit multiple different pages and then referred to like exhibit 4, pages 1 to 3, then exhibit 4, some other thing.
Your Honor,
So it basically confusing the Jesus.
it's not confusing. I'm left-handed. I do perfection work. This is in perfect order. I think the court's left-handed too and would relate.
What's not?
This is in nice, perfect order. You have the medical records and then the bills. It's 15 pages. It's nothing more than that.
Oh, okay.
So pages,
Your Honor,
I-
I don't want to take up your time. Can we submit in the morning, for example, pages, exhibit 4007 has no relationship to the preceding exhibits.
Yeah, so my suggestion was going to be to admit exhibit 4, 1 through 6. I don't think he testified as to the patient information form, how it was filled out.
Correct.
And then the billing, exhibit 4, 13 through 15.
That's fine, Your Honor. There was also exhibit 4-9 where I did ask him about, to read from the record and the court didn't want him to read that. The bottom about the prior doctors. Dr. Scher's written there. I think that's important for the jury to know that she went to this doctor before.
I'm not sure he testified to that.
He did. He talked about it.
I think there's adequate testimony for that. So
Yes.
I'll admit 1 through 6 and 13 through 15.
Okay, thank you, Your Honor.
For exhibit.
That's absolutely right, Your Honor.
Not 4-9.
Cool.
Right?
All right, and then was there anything else?
I had a 1-4.
That's the list of medical bills of plaintiff.
That is actually a list that counsel prepared.
Yes, it is. Yes, it is.
Counsel prepared.
Okay, that's not coming in now.
I would do it in closing. I'd like to show the jury the list instead of writing it down.
Well, to the extent that there's evidence supporting it, sure.
And if the court wanted to know about
I think Dr. McKenzie testified as to exhibit 2. Did you want to move any of those in?
no, plaintiff is considering that to be hearsay.
Okay.
Sorry.
Sorry, go ahead.
We offered 206, 207, 225, and 222, and we would move to admit.
Those are all the same
Those are all McKinsey?
just numbered differently, so I would say plaintiff objects to those because she's not an expert.
We used it for the facts that are recited in there and
Well-
as part of the admissions of plaintiff.
No.
And they do include, I think, at least two of the documents that counsel examined on, the plaintiff's counsel.
So I just want to make sure you understand, you want her diagnosis admitted into evidence.
I'm being told no.
Your Honor, I think all of McKinsey should be excluded because they're hearsay. She said she doesn't work
Yeah.
for this facility anymore.
Well, in addition to it being hearsay, it's got a lot of excluded expert testimony. So I'm not going to admit any of the McKinsey documents.
Thank you very much, Your Honor. Have a great day.
Anything else?
No, thank you.
Okay. No, Your Honor, thank you.
All right, see you. Why don't we,
Can I get some rest? 9:30. Please, I'm so tired. I apologize.
That's how trials are.
I need a break.
sleeps for transactional attorneys.
I'm gonna write that down.
You said 9:30, and it's always 9. What else do we have to talk about, Your Honor?
Verdict form, jury instructions were good?
Well, we've got the competing jury instructions.
Okay, why don't you work on those? And who are you calling tomorrow?
That would depend on this ruling of.
Well, I just rolled out one.
Well, on Aziz Olahi, there's no ruling. On Parsi, there's no ruling. How would I know?
The only thing we asked for was an offer of proof because we don't know who these people
Who
are.
are those people?
It's the same thing like their side, Your Honor. These are witnesses who were at the last minute thrown on the witness list. I did what they did. I'm admitting to it. The difference is I can admit to my faults.
What are they going to say?
Yeah, just what is the offer of proof? What are they going
The
to say?
same thing that their witnesses are going to say, that there was a disturbance in the building. They came out and they saw things after the fact. It's worthless. All of these 4 witnesses are worthless.
Are all objections withdrawn then? You get your witnesses, he gets his?
Well, Your Honor, he just said his witnesses are worthless.
I didn't say they were
Died a
worthless.
different court.
One at a time, please.
So there's Michael Shook, who saw the incident. There's Dr. Aziz Olahi. There's Anita Parsi. These are 3 witnesses. And if they're getting their witnesses, then I will get mine.
Well, if you just ask me, so they're witnesses to the incident,
Yes.
and you just learned of them, you didn't have,
No, I didn't learn of them. The same way that they did their investigation, we did ours, and this is what we found, and this is what we wanted to do. To streamline the case, I think what would be fair is they get to have Dr. Fininky. Malcolm is out, and if that were to occur, I would consider withdrawing a couple of these witnesses and just having 1 and 1. Maybe we'll have 2 doctors.
Malcolm is a crucial witness that both sides have witnesses who have testified to. She intervened in the argument. I don't know who these other people are, and if counsel knew about them, he was obligated to
well,
explain it.
why don't you guys meet and confer about it? We'll discuss it tomorrow, but, so potentially you've got some other witnesses.
Yes.
Okay, all right. See you tomorrow.
Thank you, Your Honor.
I tell you, the things that go down without the jury in there.